You're watching a Hanford Communities issue briefing, highlighting important environmental cleanup issues at the U.S. Department of Energy's Hanford site in southeastern Washington, issues affecting citizens of the Pacific Northwest and the nation. The Hanford Communities organization was established in 1994 and is comprised of the communities surrounding the Hanford site, forming one voice to advise the Department of Energy on important transition and cleanup issues.
Welcome to another Hanford Communities issue briefing. I'm Rob Roxburgh. On March 11, 2016, a federal judge's ruling brought to a close litigation between the state of Washington and the U.S. Department of Energy regarding provisions in the Hanford Consent Decree. That ruling sets forth new guidelines regarding emptying some of the single-shell tanks at Hanford and sets new milestones regarding construction and startup of the waste treatment plant seen just behind me here. The facility will process most of Hanford's 56 million gallons of tank waste for safe long-term storage. The federal consent decree, originally adopted in 2010, set a series of deadlines to have the vitrification plant fully operating in 2022. Judge Rosanna Maloof Peterson modified 14 of 19 deadlines, extending the completion date by 14 years and granting the state of Washington direct opportunities to return to court to hold DOE accountable if needed. She also encouraged the parties to work together and increase transparency going forward. The amended consent decree also requires the Department of Energy to provide more information to the states of Washington and Oregon on such things as funding challenges and the resolution of technical issues affecting the VIT plant. The state of Washington asked that DOE be required to build more double-shell waste storage tanks to ensure that DOE could stay on track with its overall retrieval schedule. The court refused to rule on this request because it was outside the scope of the 2010 decree. However, the judge did rule that if DOE misses the 2020 milestone for retrieving the next 5 tanks, the state will have an expedited process to ask the court to require the federal government to build more double-shell tanks. Today, D Dowell, Deputy Manager of the Office of River Protection, and Alex Smith, Manager of the Washington State Department of Ecology's Nuclear Waste Program, will provide their perspective to elected officials of the Hanford Communities and members of the Hanford Advisory Board regarding the recent ruling and the path forward for completing Hanford's tank waste cleanup mission.
Good morning, and thank you, Hanford Communities, for allowing us to share this venue today and meet and discuss the amended consent decree. This is an important decision that affects the future of our mission at Hanford as well as our communities, and this venue will aid in getting better understanding for our public. So thank you very much for having us here this morning. DOE believes that the judge's ruling on the amended consent decree was balanced, and we remain committed to the successful completion and operation of the waste treatment plant to accomplish the tank waste mission at Hanford. We also look forward to continuing to work with the state of Washington in a positive partnership as we achieve this mission in the near and distant future. Before I provide further DOE perspective, I want to briefly review the basics of the decisions made in this amended consent decree. And I'm going to refer to this handout that hopefully the audience has. This allows everyone who sees this presentation a reference or starting point for what milestones we'll deliver and when under this decree. So it's fairly simplistic. Before I get too far, we live in a world of acronyms. I don't want to kill everyone with acronyms, but if you see the term law, it means low activity waste. If you see the term SST, it's single shell tank. The term HLW is high level waste, and WTP is waste treatment plant. So you can see here the 2010 consent decree and the 2016 consent decree, the amended consent decree, which is the subject today. And these are listed in the order of chronological delivery under the new amended consent decree. So just going down them, you can see the first milestone is the low activity waste facility construction substantially completed in December of 20. Next is starting the low activity waste facility cold commissioning in December of 22, and low activity waste facility hot commissioning in December of 23. We expect to complete seed tank farm retrievals in March of 24, and we complete retrievals from 9 additional single shell tanks also in March of 24. Moving on to the pretreatment facility and the rest of the facilities. The pretreatment facility hot commissioning is scheduled by the decree for December of 33, along with the high-level waste facility hot commissioning. This also includes or is considered hot startup for the waste treatment plant. And then lastly, the waste treatment plant begins initial operations in December 31st of 2036. This gives you kind of a summary of the overall and overarching milestones that were agreed to on the amended consent decree between the state and Department of Energy. For further perspective, I've broken this down into 5 areas. Basically, tank retrievals, the focus on direct feed low activity waste, the double shell tanks and the evaporator, the technical issues and resolution, and then lastly, communications and reporting. For tank retrievals, the Department of Energy is confident we can meet the new milestones for single shell tank retrievals in the amended consent decree. The amended decree adopts DOE's proposal of March 31st, 2024 for retrieval of the 19 identified single shell tanks that were a subject of the 2010 consent decree. To date, retrieval of 9 of the 19 tanks has been completed. The amended consent decree does not mandate that DOE retrieve the remaining single shell tanks in a predetermined sequence, but does set an interim milestone to complete retrieval of 5 additional single shell tanks by December 31st, 2020. And we've already completed retrieval of 2 tanks, C-102 and C-111. C-105 we're expecting to retrieve sometime in 17. For the focus on direct feed law, or low activity waste, while the amended consent decree does not directly address the department's planned direct feed low activity waste initiative, the court did recognize that the direct feed low activity waste would facilitate achievement of the new low activity waste hot commissioning milestone of December 2023. DOE believes the milestone for completion of hot commissioning for the waste treatment plant low activity waste facility is achievable. We are also continuing to commit significant resources to the DF law effort, including designing 2 new facilities necessary to deliver direct feed low activity waste. Those being the low activity waste pretreatment system and the effluent management facility. Moving on to double shell tanks and the evaporator, the amended consent decree does not require DOE to build new double shell tanks at this time. The amended consent decree does, however, allow Washington State to petition the court to mandate the construction of new DSTs if DOE fails to meet the December 31st, 2020 interim milestone for 5 single shell tank retrievals. The 242A evaporator has proven effective at reducing the volume of waste in the double shell tanks to allow retrievals to continue and avoiding the time and expense of constructing new double shell tanks. Over 80 million gallons of tank waste removed since the facility began operations in 1977, and recently 6 campaigns since the facility's return to service from our September 2014 overhaul have created a total of 2 million gallons of storage space, which is equivalent to roughly 2 double shell tanks. DOE is in the process of acquiring a spare reboiler, which is the central mechanism that causes the heat transfer inside the evaporator, to ensure continued operations of the evaporator as required by the amended consent decree. And there's also a reporting requirement for that as well to the state. In technical issue resolution, the court recognized that the department would need 3 years for technical issue resolution, primarily associated with the pretreatment facility. We are making steady progress toward resolving these issues at both pretreatment and the high-level waste facilities. Examples are some successful testing of the half-scale vessel, and as you all saw last week, the delivery and recent installation of our full-scale vessel for further testing. In addition, construction is underway at those sections of the high-level waste facility not affected by the remaining technical issues, and they continue to make progress to this day. Timely resolution and implementation of any design and contract changes of the technical issues is key to ensuring that the department hits the new milestone for the hot startup in December of 2033, as well as the initial operations in 2036. We have a high degree of confidence that both are achievable. These milestones are 3 years earlier than the department had proposed and 14 years beyond the current 2010 consent decree. My last area for DOE is communications and the reporting requirements. DOE looks forward to open and timely communications with the state and the public as we continue to work through the remaining technical issues. We're basically reinitiating a policy of more transparency, engaging the state as partners as we continue to try and do everything we can to successfully deliver this according to the new amended consent decree. While continuing the requirements for submission of monthly reports, the court did change the existing requirements for semi-annual reports to quarterly reports. They also added 3 requirements for reporting on technical issue resolution efforts, the use of scuba or self-contained breathing apparatus, and the acquisition of the reboiler in the tank farms, as previously mentioned. The court also created a mechanism for the state to petition the court for a hearing if the state believes that DOE is not being forthcoming or not making sufficient progress. In summary, we remain committed in partnership with the state of Washington in completion and operation of the waste treatment plant, and we look forward to working with them for a targeted date of direct feed law in 2022. Thank you.
Hi, I'm Alex Smith from the Department of Ecology. Thank you also for having us here today to talk about the consent decree. I thought I'd give some perspective on why the state of Washington chose to pursue a consent decree in the first place, rather than simply rely on the tri-party agreement and the milestones in the tri-party agreement. And it goes, there's a PowerPoint that's been handed out. This is primarily for my reference, but there's a couple of charts in here that I will reference as well and point to. And the tri-party agreement, as you know, is between the Department of Energy, Ecology, and EPA. It was signed in 1989 and had some initial deadlines for retrieving waste and starting treatment of the waste in the waste treatment plant. It also has deadlines for cleanup of other areas of Hanford. But over time, it became clear that the deadlines in particular associated with retrieving waste from the tanks, as well as starting up the waste treatment plant, were slipping. And on the third page of this presentation, there's a sort of timeline that shows the various project starts and stops associated with the waste treatment plant. And it doesn't indicate it on here, but the initial date for a startup of a pilot waste treatment plant was 1999, and that obviously didn't happen. That was then deferred out to 2004, and then that deadline was missed, and that was deferred out to 2011, and then out to eventually 2019. And the state got to a point in 2005, 2006 when these key deadlines, especially associated with retrieving the waste from the tanks, especially the single shell tanks which were leaking, the state got frustrated about the sort of perpetual missing of the deadlines and wanted to renegotiate the deadlines, wasn't able to come to agreement with the Department of Energy, and finally decided that they wanted to see if we could get a consent decree or at least a judicial decree or order that would set the deadlines. And the theory behind that was instead of it just being a tri-party disagreement if the milestone was missed, it would actually be a federally enforceable decree that you go to court and have the judge enforce a decree on the state's behalf. So in 2007 or 8, I believe the state went ahead and filed suit, seeking to get some kind of a judicially enforceable order to set these deadlines. And eventually, the parties were able to come to an agreement, and that's why it's called a consent decree. It's actually an agreement between the two parties. It's just entered with the court and judicially enforceable. And that contained a new set of milestones. And I think on the 5th page, or page 7 of the PowerPoint, it sets out what was the TPA milestone and then the deadline that was put in a decree that was eventually adopted by the court in 2010. And you can see for retrieving waste from the sea farm, the single shell tanks, the deadline was kicked out 8 years. To complete WTP, the waste treatment plant construction, that was kicked out 8 years, is that right? Yes, yeah, 8 years. 8 years. And then achieving plant operations, that was a new milestone in the consent decree. That was going to be by 2022. Completing additional retrievals from SSTs, and those were SSTs that would be feeding the waste treatment plant. They were connected to the waste treatment plant mission, and that was out to 2022. And then the sort of package agreement included these consent decree milestones, but also additional TPA milestones. So the consent decree was limited to just things associated with the waste treatment plant. and the retrievals of tanks associated with the waste treatment plant startup. But there were still other deadlines that needed to be adjusted as well, and those remained in the TPA. And those included retrieving the rest of the single shell tanks, the waste from those, that was put out to 2040, treating all of the waste from the tanks in the waste treatment plant. Hopefully the completion date of that would be 2047, and then complete the closure of all the double shell tanks was pushed out to 2052, and those were all in the TPA. So that was entered, the consent decree was entered in 2010, and that was a big deal. It was a big priority of then Governor Gregoire. Within 13 months, we got word from the Department of Energy that it was likely that these key milestones in the consent decree were going to be missed as well. And a lot of that had to do with budgeting issues, and I think some technical issues with the pretreatment facility, things that JD mentioned. So the parties got together again and tried to negotiate some new deadlines and some new milestones. And the state has been sort of consistently concerned with the waste in the tanks, and that the fact that the tanks are well past their useful life and are deteriorating. And so the state really was pushing for things like new double shell tanks to retrieve the waste from the single tanks into, while they were working through the issues on the pretreatment plant and getting the waste treatment plant started. But the parties weren't able to come to agreement, and so the state went ahead and basically filed suit to try to change the deadlines in the consent decree to what the state felt were reasonable adjustments. And unfortunately, it ended up going to litigation rather than the parties being able to resolve it between themselves. But what came out of it was what JD discussed, the fair and balanced ruling from the judge. She really encouraged more transparency and working together on the part of the parties. And we ended up with the new deadlines that JD discussed. And I think on page 8 of this, it highlights those. It pushes out the retrieval of the tanks from Sea Farm out to 2024, completing WTP, the waste treatment plant construction, and starting it up to 2033. Initial plant operations in 2036. Completing retrievals from 9 single shell tanks is now 2024, pushes that out just 2 years. And then the low activity waste facility, it pushes that out to 2023, which JD was just talking about. But what the judge was not willing to do was to add new things to the consent decree. I think she felt that because the consent decree initially was an agreement between the parties, she didn't feel that it was her role to unilaterally sort of put in new things that the parties hadn't agreed to previously. So like the double shell tank, she wasn't willing to order those. They hadn't been part of the discussion earlier. She wasn't willing to order those. And she did talk about the direct feed law system, but wasn't willing to order that or put in milestones associated with direct feed law, because that was a new concept. And it is a concept that's directly associated with not having to build double shell tanks. The sooner we can get some of that waste treated by directly feeding it from the tank farms to a low activity waste treatment plant, the better off we are, and the sooner the waste gets out of the tanks that are aging and deteriorating. And so direct feed law is clearly a priority for everybody at this point. And as everyone said, the judge did say that if some milestones were missed associated with tank retrievals, the state can go back to the judge and ask for the authority to require double shell tanks. But again, that's down the road, and that's only if a specific deadline is missed. So now that the consent decree is over with, the litigation is over with, I think while the litigation was pending, the parties were not really talking to each other, and that was partly a function of the fact that, they were in litigation. And so now that that's over with, the parties are talking again, as JD indicated, and the state is committed to working with Department of Energy on what all that we can do in our role as a regulated entity and as the entity that issues permits for a lot of these facilities, to really work in the Department of Energy and making sure this happens on time. And we in particular feel that direct feed law is critical. It's essential that we get some treating of the waste and we get some glass made, and that we show some meaningful progress. We think it's important for just the site and also for showing Congress that this is a successful project. So I think that's it. Thanks.
I'm Bob Larson, Commissioner for the Port of Benton, and I'm really glad that you decided on hopefully reasonable consent decree deadlines, and we can meet those. I know that we've had problems with the tank revival, and waste treatment plant has a history of delays, and just wondered, other than what you've talked about, is DOE doing anything to mitigate the chance of further delays so we can stay on track to achieve these milestones?
Thank you, Bob. And DOE is does actually have a lot of activities that are being planned to mitigate and the timely delivery and further construction process for all these facilities. A good example is we just got done, or we're near finished with retrievals of C farm. As we move into A and AX farm as our next retrieval group, we're actually going into a process where we do all the construction first and then we shift into operations instead of going tank by tank. That is a lot less risky endeavor from a standpoint of project management and of having all the construction up front. And that way the operations can be more seamless as we go into the full retrieval of that farm. Also, as we look at the low activity waste pretreatment system, which is one of the 2 facilities that we have to construct for direct feed law, we're actually going to complete a 90% design review, and we're going to do engineering field testing of integrated technologies that will be leveraged at that plant so that we mitigate as much of the technical risk and construction risk as possible. This has not been done on the site here before from a standpoint of the rest of the waste treatment plant. As you know, we started that as a design well build. This project will actually have its design completed for the most part before we break ground. Lastly, we have a group called One System, which is a system integrator between the complex Bechtel construction contract for waste treatment plant and the tank operating contractor who is designing and constructing the low activity waste pretreatment system. You can imagine these 2 large contracts, 2 large contractors, 2 different cultures. It's imperative that we manage that very closely as we bring 2 very different systems together for the delivery of the final product, which is direct feed law.
So I appreciate your guys' perspectives on what the consent decree has done. Gave you both opportunities, but then I'm looking at the real world, and I'm looking at stop orders that have come out. It's going to impact the ability to reach your milestones, and the ink isn't dry on the agreement that you have. It's a difficult thing from a community leader's perspective to see how the state and the Department of Energy works out these issues, because you're going to have great communication now, but what do you do when things are outside your control in regards to your milestones? Is there an off-ramp, I guess, from this in regards to being able to go back to the court, set realistic milestones based on things that simply are out of your control? This has bigger concerns from a local perspective as well, because depending on whose side you're on this, the idea of double shell tanks keeps coming up, and I look at that as a very huge expense that ultimately detracts from ultimate cleanup. So that's kind of a broad-based question, but I really have concerns about stop orders, about things you can't control, and the loss of time that both sides, I think you guys are both on the idea of getting this stuff done. Man, these are things that I don't know how you control those, so I'd just be interested in your impressions on how you guys are going to resolve those kind of questions.
I'll go first. Okay. Thank you. There's no question that the stop work that was recently leveraged from our union, as well as the preliminary injunction that was received yesterday from the Washington State Attorney General, will have potential to have significant impact on our ability to deliver the schedule for tank farms. Without question, that will have an impact. We're looking at those impacts right now. It's not something I can give you details on because it's a very complex issue to manage. It's a very complex issue to evaluate from a standpoint of project execution. It literally gets down to some of the details of how and where and what people will be doing step by step as we approach our tank farm work. So we do know that it will be friction against the ability to achieve that work. Our efficiency levels with our workers will do nothing but decrease as we layer on additional measures and controls that are mandated by the state. That said, overarching for Vapors itself, we're here to make sure our workers are safe. We're making every effort, I believe, possible to ensure that we are thorough and looking at the things that we have to look at to be able to justify technically that people are safe on the site. So, a more direct answer is that there are potential impacts. They are significant. They could bring us back from a standpoint of a force majeure with this consent decree back in front of the judge. And I'm not going to predict what the judge will do with that, but it could very well trigger some of the things that the consent decree has managed for us to reevaluate double shell tanks or at least progress towards the milestones which are under jeopardy by and risk from that increased litigation or increased controls that are measured by these actions.
And from the state's perspective, we're also concerned about stop work orders and slowing down or stopping work, the critical work at the site. But to answer your question about the consent decree and is there leeway in the consent decree, there is room in the consent decree, and I think because it is an agreement essentially between the parties, we can always together, hand in hand, go back to the court with new milestones or new dates for things. So that's always an option. If one side wants to unilaterally change them, then they'd have to go and petition the court. But again, as JD indicated, there is a provision that says if there are things beyond your control, a force majeure, then you have the ability to go back to the judge and make your case for why a deadline should be moved. So that room is still there. But it's a tough issue. I think the state attorney general feels very passionately about it currently. And everyone supports the worker safety, but we also want to make sure that the important work at the site is able to continue. The Attorney General is in charge of this litigation, and they didn't communicate extensively with my program before doing this, and they are making their decisions independent of what the governor may want and what the Department of Ecology may want or want to have done. So we received limited notice that the preliminary injunction was coming. I did provide a heads up to ORP as well as the WRPS, but the Attorney General is really acting in his independent role as a independently elected official on this.
And we did not receive any other notification other than the heads up.
Good morning, everyone. I'm Philip Limley. I'm a member of the Hanford Advisory Board. You might have already answered this question, but if the DOE is not able to meet the 2020 milestone for cleanup or for retrieval of the single shell tanks, and the courts mandate more double shell tanks, do you have any idea of the time and cost and how that will impact the rest of the cleanup?
Thank you, Bill. And yes, we do actually have, and I can give you rough orders of magnitude. We've actually contacted the original vendor. We've also done some preliminary review work to understand exactly what kind of a liability that would be and cost. And rough estimates are between 5 to 7 years. Of course, these would be RCRA compliant storage facilities. That brings a level of complexity, a level of permitting activity, a level of redesign from the standard tanks we have today. We would also probably take the opportunity to design them better as retrieval tanks instead of just storage tanks. So there'd be a lot of work in that design, as well as the regulatory process would be higher. The estimated cost is anywhere between $80 to $120 million. Of course, there's economies to scale if you build more than one. And that's again, a very rough estimate. We call it a rough order of magnitude, a ROM estimate for those kinds of activities. So 5 to 7 years and $80 to $120 million per tank.
Was retrieval designed into the double shell tanks?
It's definitely designed into the double shell tanks better than it is for the single shell tanks. That said, there's ways you could improve them. They're very old design. All right, I'd like to thank Hanford Communities for this venue, and I hope that we've answered questions about our future here, our near term as well as distant future in the amended consent decree. We look forward to working in partnership with the state of Washington to start delivering and working towards the final remedy for this high level and low activity waste in the tanks and tank farms. Thank you today. Thank you for everything today.
Yeah, thanks also for the opportunity to be here this morning. And as JD indicated, we look forward to working with the Department of Energy and making meaningful progress on cleanup at the site.
A special thanks to our guests for joining us today, and thank you for watching. This has been another Hanford Communities issue briefing.
To find out how you can become more involved in this important regional issue, or to have a Hanford Communities speaker talk to your organization, contact the Hanford Communities at 509-942-7348 or visit our website